case. As you know, it's been on the dock for a long time. It's a civil case. Has the court seen the complaint?
No.
We can give the court a copy of the complaint. It is a civil action, Your Honor. There's a couple of counts, 3 counts. One is for negligence, second is gross negligence, and third is intentional tort.
All right.
There is one defendant and one plaintiff, and this jury hasn't been given any previous instructions. There are some stipulations. I don't know if you want to just take a minute, Your Honor. Do you have a whole packet there in front of you?
I do.
So take a look at number 13. Number 13 will give you more or less the witness list. We have 3 witnesses for the plaintiff, 3 for the defendant.
All right.
There are a number of exhibits that may or may...
Is this the plaintiffs at this table over here?
Who's here?
Yeah. All right. Good.
And what we do is we have 3 of the... we have some lawyers and with some witnesses. They're all going to be exchanging, and different people will be giving opening statements, closing statements, things like that. There are a number of exhibits, and they have been instructed on the form of seeking to introduce exhibits. On page 14, you'll see some stipulations. If you just want to take 30 seconds and read over the stipulations on page 14.
Page 14.
I would also ask young men here to take a minute and read page 14. That gives you the page 14 and 15. These are stipulations that cannot be contradicted or challenged. Your Honor, also, if you want to take a minute during the opening statement to read the complaint over, you'll find the complaint on page 6, 7, and 8, and 9. And the answer will be on 11. There is one affirmative defense by the defendants of assumption of risk. Let's just see. The jurors here, how many jurors do we have? Are we going to have 6 jurors? 1, 2, 3, 4, 5, 6. Mr. Lisbon, these are 6 jurors over here. So, Judge, I'm not going to ask that you swear the jurors in, but I would like for you to give them some general instructions. And in terms of, and then at the end, we don't have any real jury instructions, but I'm going to, since you presided over so many negligence type trials, this is a bread and butter type negligence case, you'll be able to give them, we have some jury instructions here at the end. Where would they be? Boys, where are the jury instructions?
What page?
Page 40.
We really appreciate you taking the time.
47.
Page 47?
Yes.
So, yes, page 47 is a jury instruction for negligence. There's a pattern jury instruction 48 for battery. And on 49, that's it. So it's going to be 47 and 48 are the jury instructions. So, Your Honor, I'll let you go ahead and take over. I'm going to sort of sit in the wings.
We're here in the matter of Cameron Duncan versus Robin Hightower. Will the attorneys for the plaintiffs state their names for the record?
Ellie Green.
Good afternoon, Mr. Green.
Ellie Bortunk.
Good afternoon, Mr. Bortunk.
Nati Zigelbom.
Good afternoon, Mr. Zigelbom.
Menachem Benchimol.
Sorry, I didn't get your name.
Menachem Benchimol.
What's your last name?
Benchimol.
How do I spell it?
Kenchimol.
A little hard to hear, guys. I need you all to speak up because it's difficult to hear.
And for the defense?
Schneur Cohen. Gheblikian. Razla. Goldberg.
Good afternoon to you all. Gentlemen of the jury, this is a civil case. The standard of proof in a civil case is a preponderance of the evidence. Whichever side ultimately demonstrates its case to you more than the other side will prevail. Ladies and gentlemen of the jury, during this trial you are to pay close attention to the witnesses and exhibits that are placed before you. That is the only evidence that you can use to decide, ultimately to decide your verdict. You should not assume that I have any not for one side over the other, regardless of what I may rule on a given issue. You all are the finders of fact and will ultimately determine the verdict. The plaintiff, would you like to make that opening statement?
Good evening, ladies and gentlemen. My name is Menachem. I'm members of the jury. My name is Menachem, and I'm representing Cameron Duncan, an ex-student of Douglas High School in Lisbon. I intend to prove that Robin Hightower intentionally, with malice, injured my client in a basketball match. These are the facts. Robin Hightower is known for having
Mr. Benchimol, you can tell this to the jury. You can turn this over to me.
These are the facts. Robin Hightower is known for having a really high level of anger temper, known even by his teammates. Both Robin and my client were captains in rival teams. Both teams reached the Florida State Championship. Lee Lane, a co-captain with Robin Hightower at Chris High School, and my client's cousin, has been asked by his teammates to speak with Robin about his touchy behavior before they get labeled. They knew he needed to be calmed down before the big game. Before the incident, there was an accidental bump between Robin Hightower and my client, which hurt his nose. The referees called it an unintentional foul. It was a really intense but fun game until the last second when Robin Hightower intentionally tackled my client to the ground, injuring him and giving him a paranoia of a lifetime that with a small movement could take his ability to walk ever again. Today, Cameron will be represented with evidence and testimonies from witness Mr. Lee Lane, Robin Hightower's co-captain at Chris High School, and Cameron Duncan's cousin, who was asked by his teammates to try to calm him down before the big game, and says he saw clearly how Robin Hightower rushed into Cameron first. From Mr. Potterback, Mr. Cameron's coach, who in his expert opinion, says Robin purposely tackled Cameron to the ground and has known Robin for having a bad temper. And the last witness will be Mr. Cameron Duncan himself, which Mr. Hightower ruined his life, saw as Robin rushed into him fiercely and injured him badly. This will leave you no doubt in your mind that the guilt of the defendant. Members of the jury, ladies and gentlemen, I thank you for your time.
Thank you. Does the defense wish to make an opening statement?
Yes, Your Honor. Good evening, ladies and gentlemen, and welcome to the case of Cameron Duncan versus Robin Hightower. My name is Mark Goldberg, and I would like to acquaint you all with the witnesses in brief description and their testimony and explanation with some basketball terms. But first, I will start by telling you what transpired that fateful day. My client, Robin Hightower, was a student at Chris High School. While attending high school, he played varsity basketball. He, along with his teammates, set out for a long and hard journey to make it to the championship game. And sure enough, with hard work and determination, they made it. During this milestone game, an incident occurred. While reaching for the ball, my client, Mr. Hightower, was hit in the nose by Cameron Duncan, the plaintiff. After which, my client was taken off the court to be evaluated and treated. During the evaluation, Robin was told by team staff to sit out for a while. But the thought to leave his team in a time of desperation was completely non-existent. Therefore, Robin got back on the court to continue to strive for his team. Shortly after this incident, another incident occurred. My client was playing defense and Cameron was wide under the hoop to hit the shot to win the game. Seeing the man open, he dashed over to cover him. While running over, the ball was passed to Cameron. Robin raised his hands to block the ball, but while attempting to make a play on the ball, he simply slipped on a wet spot and bumped into Cameron, thereby accidentally causing Cameron to fall into a ball rack, which causes injury. I want to stress that this was not an act of violence, yet a mere incident that unfolded by accident. Today you will hear from many witnesses, and I would like to take a moment to go through what you will hear. You will hear from Ken Redelman, Robin's high school principal. He saw Robin and how he acts on a regular basis. He will tell you how good of a student Robin was and how he would never want to hurt anyone. You will also hear from Mr. Redelman that he's been to many games in the past, and there are times when players have gotten hurt. Next, you will hear from Mr. Artis Michael, a sports agent, who's been observing basketball games for years. If anyone will know the truth of how physical close games could get, he would be the one to know. He will tell you that over his career, he has seen firsthand thousands of collisions. And this one, which had a hard impact, was neither malicious nor unfair. And due to the fact that players take on an assumption of risk, they should know that this isn't ballet class, and players could get close at any given time and at any given moment. Last but not least, you will hear from the defendant himself. What you will hear from him is that he slipped on a wet spot on the court, resulting in colliding with Cameron. For this, he was issued a personal foul, the same infraction as Cameron was issued when Robin was hit in the face. Due to the fact that they received the same penalty, only comes to show that the severity of the incidents were equal in both cases. Now, ladies and gentlemen of the jury, I would like to show you, see, that what falls under a personal foul. Now, what falls under a personal foul is contact between players that may result in injury or provide one team with an unfair advantage. Players may not push, hold, trip, hack, elbow, restrain, or charge into another opponent. Now, ladies and gentlemen, if my client was actually charged for a more harsher charge, he would have been issued a technical foul. Now, a technical foul, in the regulations to Crisp High School County, he would have been ejected. Now, technical foul has as follows: an infraction of the rules during the course of play between players on the court that generally does not involve physical contact, or foul by a non-player. The most common technical foul is for unsportsmanlike conduct. Ladies and gentlemen, I thank you for your time, and hope you find in favor of the defendant, and God bless America.
I want the jury can't look at that.
All right, Mr. Goldberg, take your exhibit back and tell you how much it's been introduced. Plaintiff, you may call your first witness. Come over here. Raise your right hand to affirm. You affirm the testimony you're about to give will be true and correct to the best of your knowledge. You may be seated.
Over there.
Why are you looking here?
Please state your name.
Leslie Lake,
At the time of the incident, what school were you attending?
Chris High School.
What was your relationship with the defendant?
I was a co-captain with him at Chris High School and a long time ago.
What was done the night before the game?
It was a pep rally
So besides you being co-captain with the team, for what reason were you there?
because I wanted to talk to him before the game, because of his touch and behavior.
So was there any specific reason you were at talking before the game?
Because there was pressure on the court and I didn't want him to do something.
So why did you bring Cameron to the pep rally?
Because dealing with these cases on personal on this kind of cases, I wanted to have two people instead of one because I didn't know what he may do.
So what happened when Robin saw you talking to Cameron at the pep rally?
He instantly started calling out, like saying that, started screaming at us, and said something about having the score during the game.
So were you and your teammates aware of the recruiting the fans at the game?
The score.
Did anything in playing the game change after you were aware of this fact?
No, but Robin started playing like, Robin had the pressure of playing hard because he knew there was a scout over here.
What factors do you think led up to the incident between the defendant and Cameron Duncan?
Because Robin knew that Cameron also was a good basketball player, and he needed the scholarship really badly, so he made him take him down.
No further questions.
A cross-examination of the witness.
Yes.
Lee Lane, are you related to Cameron Duncan?
Sam.
Have you been to his house?
Yes.
You're his first cousin.
Yes, I am.
And you even went to family events with him. So, you would probably defend him in any situation.
Only if it's the truth.
Only if it's the truth. So tell me, was Robin trying to get the ball?
Nope.
No. Can you read minds? How could you tell that?
Because the ball's over here, he was facing this way.
Facing that way. Can't read minds. How many years have you played basketball for?
Since I was born.
Since you're little. So, you would know the game.
Yes.
So you would know it's not rare for people to get a big aggressive in challenging games like the sword.
Yes.
And isn't it true that in sports, when physical contact occurs, emotion kicks in and people get a bit, on the angry side? And you never had such an incident before?
Not as bad as this one.
Not as okay. So tell me, in a tight ball game, did you expect Robin to sit there and watch the ball and let Cameron score? Okay. Okay, I'm done with this witness.
All right, any redirect examination?
No.
You may step down. Thank you very much. Plaintiff, you may call your next witness.
I'd like to call Cameron Arbach.
Raise your right hand. You affirm the testimony you're about to give will be true to the best of your knowledge.
What is your name?
Arbach.
Where do you work during the incident?
I was head coach for Douglas High School.
What other jobs have you had?
I've been head coach for 10 years, assistant coach 6 years previous to that, and refereed this summer basketball game in the 1980s.
Your Honor, I can't hear the witness speak, so I can't object if I can't hear them.
All right, you want to speak up a little bit.
Have you ever played basketball?
Yes, I was starting point guard in my senior year of college at State University
Why was it stopped?
because of a leg injury during the pickup game.
I would like to classify this witness as an expert witness.
Any objection from the defense? Hearing no objection. Is there an objection? No objection. So ordered.
How long have you known Cameron Duncan?
For over 10 years.
What kind of player is he?
He's a clutch player who actually seeks out the ball in any situation. He's a kind of another coach on the field.
Do you know Robin?
Yes.
Was he a good player?
Yes, he's
I
a good
object.
player.
I can't hear the questions and a bit, and it's cutting out on the answers too.
All right, so I'm going to ask both the attorney and the witness to speak louder. And also, if you want to move your chair up here for the purposes of this witness, if you're going to be the attorney that's doing the objection so you can hear everything, feel free to move over.
That's not a bad idea. If one of you wants to move up close.
Move up here. You can either move your chair or stand at the other podium. All right, Mr. Bortunk, you may proceed.
Was Robin a good player?
Yes, but he was mostly just raw talent, not a fully polished player.
Was there anything special about how he played?
He just mostly just raw talent.
Have you seen Robin get upset?
Yes, multiple times.
What would he do when he gets upset?
He would curl his lip upward.
Does he do this often?
Yes.
Did he always do what this team wanted?
No, he would mostly do what he felt would be beneficial to himself, regardless of what helped the team.
What's your objection, sir?
How does he know?
Opinion. I respectfully overrule the objection. Witness has answered the question.
Do you think he was a polished player?
No.
What was Robin doing during the huddle?
He was watching over at our team instead of listening to what his coach had to say.
Were the teams well matched during the championship?
Yes.
Did anything happen before the incident?
There was a bit of spirited play under the basket, and Cameron accidentally hit Robin in the nose, causing bloody nose.
Did Cameron get a foul?
Yes, he got a personal foul, even though it was entirely accidental.
Who was guarding Cameron during the game?
Robin.
Did Cameron get free from Robin?
Yes, he did.
How close were you from the incident?
Just a few feet away.
Did you see anything that he could have slipped on?
No.
In your expert opinion, what kind of foul was it?
There was an entirely flagrant foul that was done maliciously and intentionally to hurt Cameron.
I have no further questions.
Or cross-examination.
Mr. Auerbach, you've been associated with basketball since the 1970s.
Yes.
That you were a coach, that you're even going to make it into the professional European basketball league.
Yes.
So you would say that you know the game of its risks.
Yes.
And that it's uncommon, that it's not common for injuries to occur during a game.
Yes.
That even players might get emotional after being hit or a bad call.
Could be.
Yes or no?
Try to keep those in check.
Yes or no?
Yes, but.
Yes, okay. So do you think Cameron knew his risk before he started playing basketball?
Yes.
So tell me, Mr. Auerbach, do you think Robin is a hothead?
Yes.
A one-man show?
Yes.
Would you not? Would you want him on your team?
With a little bit of
Yes or no?
training, yes.
So you dislike Robin?
No.
Okay, I'm done with that one.
Any redirect examination? No. All right, thank you. You may step down. Plaintiff, you wish to present another witness?
I'd like to call Cameron Duncan.
Affirmative, the testimony must be true and correct. The testimony must be
What is your name?
Cameron Duncan.
Which college are you attending right
I don't remember what it's called.
now? Which school did you graduate from in 2008?
Chris High School. I don't remember.
Anything happened between you and the defendant the night before the game?
Yes.
What happened?
My cousin called me to go to the pep rally, and the defendant started just getting mad at us and cursing us out, arguing with us
Where was the pep rally?
at the Cohen school
Why did you go to the pep rally?
because my cousin called me to go.
What do you want to show me, your cousin, at the pep rally?
That I got a full academic scholarship to college.
What did the letter say?
That it was irrelevant. It had nothing to do with sports, and it was purely because of my grade.
Did Robin's appearance change?
Yeah, as soon as he saw us, he made an angry face and just lost his cool.
What did Robin do when he came over?
He started arguing with us, insisting about settling the score at the game.
Why didn't you think anything of it?
Because Robin he always had a temper.
Is it a known thing that Robin has a temper?
Yes, it was.
Why was Robin under pressure to perform well during the game?
Because there were these scouts there, and it was his only chance to make it.
Why weren't you worried about an athletic scholarship?
Because I had been already accepted to college.
Why are you glad you did that?
Because I'm glad that I had great grades, because now that I'm crippled and I'm never able to do basketball again, I will be nowhere without those good grades.
Why do you think you made Robin even angrier during the fourth quarter of the game?
Because I accidentally elbowed him.
What did you do when the game stopped?
I immediately went over and apologized.
What kind of foul did the referee give you?
Personal foul.
Why didn't they give you a technical foul?
Because it wasn't aggressive or on purpose.
What would have happened if the refs had given you a technical foul?
I didn't reject it.
What is the difference between a personal foul and a technical foul?
Personal foul would be just because just because it happened, it wasn't necessarily on purpose or just the heat of the moment. And the technical would have been an aggressive, on purpose, and wrong, like from beginning to end, wrong.
Do you see anger in Robin's face?
Definitely.
What type of injury did you sustain?
I fractured my lower spine and I lost feeling in my legs.
Are you doing anything to help it?
Yeah, I have physical therapy all the time.
Did the doctor tell you anything concerning your leg?
That I should refrain from anything that might make it worse, like sports and stuff like that.
Did he send you a letter?
Yes.
What did the letter say?
That even a small accident, like something hitting me in the back would permanently injure me.
I'd like to present Exhibit D.
All right.
Where is the exhibit?
You first show it to the attorney for the defense.
Boys, help him out. Help him find his exhibit. You're going to be putting in more exhibits later. Have them ready. You're going to have them ready.
All right, first show the exhibit, please, to the attorney for the defense. Do you have any objection to the entrance of the exhibit? Without objection, it should be admitted as plaintiff's exhibit.
Objection?
You do have an objection?
Yes, hearsay.
All right. What's your response? Mr. Bortunk, may I see the exhibit? Do you have a response to the defense objection to this hearsay?
We just have a minute to discuss this.
Are there exceptions to the hearsay rule? So you need to stand up. Okay, so you point that out to the judge, but you still have to prove relevance. And if there's an exception to the hearsay rule, go to where it talks about hearsay. Read that, stand up, and address the court.
You can do it.
Dr. Mathewson's letter to Cameron Duncan, Exhibit D, was made and kept in the regular course of the hospital business and satisfies all the requirements of the business record, exception to the hearsay. The context of this letter are an accurate depiction of Cameron's injuries sustained at the basketball game in question.
Defense, anything that you wish to state in opposition to that? If the court respectfully overrules the objection, I admit the document to the plaintiff's exhibit. You wish to publish it to the jury?
I have no further questions.
Any cross-examination of the witness?
Cameron, please answer in yes or no. Isn't it true you gave Robin a bloody nose?
Yeah.
And a foul was called?
Correct.
And would you assume that the refs know the rules of basketball?
Yes, I better hope.
So the refs called a personal foul on you.
Yes.
And you played basketball for a very long time.
That's what we call a long time.
Junior high.
Yeah.
So, I mean, from you playing that long, you know the risks and benefits of the game.
I don't know, 3 years is a long time.
Junior high and high school is a lot more than 3 years, buddy.
Okay, buddy.
So, would you know how intense and aggressive the game can get?
Yeah.
So, and that people may jump into each other over on fast plays trying to get the ball.
Yes.
So, Cameron, can you?
Counsel, kindly refer to
Play that was contact made by mistake.
Consisting of
A bunch of
elbows, pushes, Yeah. So, which is more severe, a personal or technical?
Technical.
So let's say you were called with a technical foul. You would have been ejected from the game, correct?
Correct.
Was Robin ejected from the game? Or was he issued a personal foul like yourself?
Personal foul.
I'm done.
Any redirect? Anything else on the plaintiff's lawyers? I think it's done being mixed up now. Plaintiff, do you wish to call another witness?
They don't have emotions.
All right. Plaintiff rests. Does the defense wish to call any witnesses?
Yes, Your Honor.
All right, defense, you may call your first witness.
Defense like to call to stand Ken Redelman.
Do you know that you affirm the testimony you give is true? You may be seated.
Please state your name. What is your profession?
Principal at Precisely.
How long have you been working there?
Past 10 years.
Please speaking up. Do you know the defendant, right?
Yes, ever since he came in.
I can't hear.
Hold on, Mr. Rodeman, what's the objection?
I can't hear the witness or the questions being asked.
All right, Mr. Bortunk, why don't you come around here and stand at the podium?
Do you know the defendant?
Yes, ever since he came in middle school, he was playing
What does he play?
basketball.
So Robin is enrolled in your school.
Yes.
How was Robin as a student?
He had good grades, good sportsmanlike conduct. He helped people that were less fortunate. Never got into fights.
Does Robin cause trouble in school?
No.
Does he fight in school?
No.
Has he ever been involved in a physical dispute?
No.
Were you in attendance of all the basketball games?
Yes.
Were you at the championship game?
Yes.
Was there an incident with Robin?
Yes.
Please tell us what occurred.
Plaintiff, Mr. Duncan, elbowed Mr. Hightower in the nose, causing bleeding.
Are nosebleeds and other injuries common in the game of basketball?
Yes.
Okay. Was there another incident?
Yes.
What was it?
Mr. Hightower was going for the ball and slipped and fell to Duncan.
So how did this happen?
He slipped on the
He slipped? Do you see any reason why Robin would want to hurt Cameron?
No. If he did, he would ruin his chances to get into the scholarship.
The first question here.
All right, any cross-examination from the plaintiff?
Yes, I do.
Steve, just a witness.
You, Mr. Rendelman, you spend most of your time walking around the bleachers talking to parents and scouts and whoever's there, correct?
Yes.
And do you pay attention to the game?
Sometimes.
And have you ever experienced troublesome activities in the past?
Yes.
So what have you done? Have you issued anything to prevent further issues?
Yes.
And so you work with your players and coaches to behave and yes, least, I don't know how to say it, as little aggressiveness as possible?
Yes.
Okay, thanks. Also, you were in the stands during the game, right?
Yes.
And did you witness the elbow?
No.
A minute ago you said you did.
I said I heard it.
Yeah, he asked you, did you?
In the,
Okay, great. Anyway, so would you be able to say anything about it?
no.
So why have you?
Because he asked about an incident.
So you lied about it?
No. What happened?
You said you saw it. He said, did you witness what happened between Cameron and my client and Robin Hightower? And you said, yes, I did. My client, you said, elbowed his client, and you said you saw it.
I did not say I saw it.
Okay, whatever. Did you think about what happened and did you take any course of action? What happened between your client and their client and my client?
No.
but you're working too. Did you speak to your client after what happened with the elbow? Did you see what happened at the end of the game?
Yes.
And do you agree with the fact that since you taught them not to be aggressive, that it shouldn't have happened on purpose?
Yes.
And you also as principal, if something would have happened on purpose, let's say somebody lost some control and kicked somebody on the court, let's say, or better yet, beat them to a pulp, let's say, what would you have done? Okay, and if it was worse, let's say somebody killed someone on the court, what would you have done?
Yeah. We're gonna hear this.
If you said in your sworn statement that you would take corrective action rather than hand them over to the police.
Not the police.
So if somebody murdered someone, you wouldn't tell the police.
That's a different story.
It is entirely appropriate for the school to take corrective action rather than the police. Does that not mean what I just said?
The Florida High School Basketball Association is not the police.
Neither is but your school is not the Florida High School Basketball Association.
But if it had to do with basketball, I had to go over there besides the stuff that we would do.
Okay. So you would protect your kids at all costs, then turn them over to the police. You'd rather hide them from the law, than turn them over to the police. So why would you not turn them over to the police?
Because it wasn't a murder case.
It says here that if something would have happened, you would not turn them over to the police. I'm not talking about our case.
A murder case is something else.
I'm not talking about our case or
Then I wouldn't-
any other
then if
case.
I'm not talking about my case, then if it's not a murder case, I wouldn't hand them over.
Okay. Also, would you classify 18-year-olds as adults?
Yes.
And so you would, so everything you do here, it says here that it's different between adults and kids, and you would treat them as kids rather than adults. Is that true? You said that?
Yes.
So not true. You did not say that. It says right here, I'm not sure that it's all fair.
Objection, Your Honor. What is it? It says right here.
In his testimony. His testimony. His sworn statements on it.
You may proceed.
Is the threshold for what is tolerated different for kids than adults? Do you tolerate? Okay, never mind. Also, Robin has been a good student in the past, correct?
Yes.
And he helps others, correct?
Yes.
And he was the first one to sign the code of conduct.
Yes.
Can I enter the code of conduct as an exhibit?
Please show it to the attorneys from the defense. Is there any objection to the attorney to the exhibit?
No.
Yes, it will be introduced as plaintiff's defense. Without objection. They have it. It's admitted. Plaintiff's exhibit 2. Nobody even shows it
It may be on the back side, there's another exhibit number. If so, only look at the code of conduct if something else is on the other side.
In the code of conduct, it says that you would behave, or not behave, but you would do your best and not act you would behave in public. So do you hold the responsibility to make sure your children behave, or your students do what it says in that?
Yes.
Okay, no further questions.
All right, thank you. Any redirect? Well, you may step down. Defense, you may call your next witness.
I call the sign.
Mr. Art Michael? You affirm the testimony you give will be true.
Yes.
You may be seated. What's your name?
Ars Michael.
What do you do for a living?
I am a sports agent for athletes and professional athletes.
What sport are you an agent for?
I'm a sports agent for basketball.
How many years of experience do you have?
Over 15 years.
Would you say that you are knowledgeable in the rules of basketball?
Yes.
Your Honor, I would like to admit this witness.
Any objection?
No, Your Honor.
Right, so ordered.
Did you attend the game in which Cameron was injured?
Yes.
Have you seen many games with these types of injuries?
Yes, I have.
Injuries are common during the game.
Yes. Injuries are common.
Did you see what happened?
Yes, I did.
How close were you?
I was in the scouting section, which is right behind the press table.
Was Robin acting malicious?
Yes.
Do you think a seasoned basketball player that knows the rules and has played the game for years assumed the risk and injuries?
I'm sorry?
Do you think a seasoned basketball player that knows the rules and had played the game for years assumed the risk of an injury?
Yes.
Yeah, I'm done.
Thank you. Any cross-examination?
Yes,
Please.
what is your name?
Arts Michael.
Thank you. Okay, so we have agreed that you are a professional in the matter of basketball, correct?
Yes.
And you had a few hot prospects at the game on that
Yes, I did.
April night. And who were they?
The coaches introduced me to a few of the players.
That doesn't help me. What's better? Was Robin Hightower one of them?
Yes, he was.
And what would you agree that he would have been a good, if you were to sign him or be his agent, it would have been a good investment for you?
He's what we call in the business one and done. You know,
So
they have 1 year of college and then they go straight up to the NBA. He's a great.
So his goal was to become a professional basketball player?
Yes, it was.
Okay. So Robin was playing good on the night in the game. You liked what he was doing, correct?
He was playing very well.
And if, let's say, he were to buzzer beater 3 to win the game, he would have been a bigger prospect than he was before, correct?
I wouldn't say bigger prospect.
But
I would say
better.
it gives it makes it. Big games give chances for small players to make big opportunities and get a bigger deal.
So so a player would naturally work harder during a game if you were there.
Not necessarily.
If a player knew you were there and they wanted to go to the NBA, their lifetime goal was to go to the NBA.
I guess you could say that we work harder.
Okay, so that's what I wanted to know. Can you describe for me the difference of how Robin was playing before the elbow and after the elbow?
He was playing fairly the same. You know, all game he's always trying his hardest to play on top of his game.
It says in your testimony that you, as a professional in basketball, saw him play much more aggressive after the elbow.
It says I think.
So you don't. So what do? You don't think now?
I do think.
Okay, so you told whoever wrote that down that you thought that he played aggressive after that elbow.
I wrote that I thought that what happened with Cameron, what transpired with Robin in the beginning of the game, led to the actions after. It says I think.
You also said that you witnessed Mr. Hightower run into my client. Is that correct?
Yes.
And it was a hard foul. Is that correct?
Yes, I had a hard impact.
And do you think it was provoked?
I don't think it was intentional.
Do you think it was provoked? Then ask if it was intentional.
No.
It says you thought it was provoked.
Okay, so it's provoked.
And you say that it was an important game and there were a lot of things on the line. Can you tell me what was on the line for any of the players?
Scholarships.
So basically their life, their careers,
Most of them, I mean, whoever wanted the chance to go to the NBA, obviously they could do what they want. They have the option.
So for somebody who needed to go to college in order to go to the NBA,
their career depended on that night because you were there. So wait, I'm asking a question. Talk. Okay. So so it makes sense for somebody to act and work a lot harder and a lot more aggressive at the end of that game, right?
Yeah, they would continue to strive at the top of their game.
No more questions.
All right, is there any redirect from the defense? Ready, may step down. Defense, do you wish to call the next witness?
Yes, I'd like to call my brother Hancock.
I tell you, meticulous. You affirm the testimony given will be true?
I did.
What is your name?
Robin Hightower.
How old are you?
I'm 18.
What school did you attend at the time of the incident?
First high school.
Did you play sports while attending high school?
Yes.
What did you play?
Basketball.
What position did you play?
I played forward.
What game in the season did the incident occur?
Final championship game.
Did you know the plaintiff?
Yes.
Do you have a good relationship between one another?
Yes.
Do you enjoy the game of basketball?
I love it.
Why do you play basketball?
Hopefully I can, through my ability to play well, I will try to get into the NBA as a scholarship in college to hopefully later on get into the NBA.
Where were you the night before the game?
On my school.
How were you there?
For my school's prep rally.
Did anything occur that night?
Yes.
Who was involved? Did anything occur that night? What occurred?
An argument between me, Lee, and Cameron.
Was there any physical exchange that took place?
None whatsoever.
Was that the last thing that happened that night?
Yes.
Who did you guard at the championship game?
Cameron Duncan.
Was there an incident that occurred with Mrs. Duncan?
Yes.
What was the incident?
He elbowed me in the face.
What happened after the incident?
I got a bloody nose. I was taken off the court to be checked by doctors.
Did anything else happen?
The doctors told me not to go in. I went in because, I felt like my team needed me. I had to jump in there and make the game.
After you returned to the game, was there another incident that occurred?
Yes.
What was it?
I slipped on a wet spot and fell over Cameron.
They call it personal foul, not a technical foul.
Yes.
Did you intend to hurt Cameron?
No.
You tried to help him?
Yes, I tried to grab him to help break his fall.
What do you see yourself as in the future?
An NBA basketball player.
I'm done questioning these.
Okay, thank you. Plaintiff, any cross-examination of the defense?
Yes, I do.
Ms. Duncan, who was your co-captain?
Lee.
And oh, I'm sorry.
My name is Robin.
Mr. Hightower. Yeah, I know.
Robin.
I thought I was talking to myself.
Okay.
So your co-captain was Lee Lane, correct? And you knew that she was cousins with, or he was cousins with Cameron Duncan.
Yeah.
And as a fellow teammate, you respected her, correct?
Yeah. I don't think they should be speaking on the night before this big game.
So you wouldn't talk to your family the night before the big game?
Not if they're rivals, friendly rivals.
But you said in your statement, in your sworn statement, that you guys are arch rivals.
Arch rivals.
And
My
prep rivals. So
my school are arch rivals, but I'm friendly rivals.
But aren't you part of your team?
There's my team, and then there's me.
But you said just now you said that your team needed you as if you were your whole team. So you're friends with your team while the rest of your team are rivals, except Lee Lane because they're cousins.
No.
Which one is it?
It can be all of them because there's my team, and then there's me, and then there's Lee Lane and Cameron.
So when you're part of your team, you're arch rivals. When you're not part of your team, you're friends. When Lee Lane is part of your team, she's arch rival, and when she's not part of your team,
as in a school, as in a team, we're arch rivals.
But as you said at the pep rally that things would be settled the next day, correct?
Yes.
And you said in your sworn statement that the threat wasn't meant to be physical, is that correct?
Yes.
That's all. Okay. Did the next day when Cameron bumped you in the nose, did he apologize?
Elbowed me? Or he elbowed me? Yes, he did apologize.
And did you? And what did the ref call?
Called a personal foul.
Did you agree with the ref's call?
Yeah.
But if you believe that it was on purpose, if it was on purpose, then the ref's call would have been false according to you. It wouldn't have been a good call. So was it on purpose, or was the ref? Did the ref make
I
a
mean,
call?
the refs can't read their minds. They just do something from what they think.
So
And then it wasn't
the
elbow
refs
over
aren't
the
perfect,
head.
correct?
What?
You're agreeing with me the referees are not perfect, is that correct?
They're perfect. I mean, they're not perfect, but they can't read minds. But they know the rules of the game on what looks like what. That's what. That's their living. That's what they get paid for.
Their job is not to decide what it looked like. They need to make a call.
And that's
make
what
sure
they
the rules
did.
are correct.
They made a call, and that's what happened.
And but according to you, it was not a good call. Is that correct?
According to me, is not what according
I'm
to the
asking,
refs.
according to you, I didn't. Is a referee sitting in this chair?
You brought up the refs.
And I asked you, Robin Hightower, what you believe a good call would be.
Good call. A purpose elbow to the face.
So a tactical foul.
I would assume so.
So you also then if the referees aren't good at their they make mistakes sometimes.
Remember, I get elbowed in the face and emotion kicks in. So at the time, yes, I thought. And when I was
now you don't think you
No, I do think. This
emotion calmed down. It was
months ago, but that statement was also made. Today.
Here. Okay, it wasn't months ago.
Okay.
Anyway. So when my client came to apologize to you, what were you thinking when you did that?
I do not recall.
We just discussed that you thought you did on purpose.
Yeah, on purpose, yes.
So
I thought you could
so
mean
going through
something
your
else.
mind, he's lying to me. He doesn't really apologize for doing what he said was by mistake. Does that make sense?
Yeah.
Okay. So later in the game, your coach called a new defense, and you ran into him. Is that correct?
I slipped over the West Ball.
You slipped and bumped into him.
Yes.
And let's say that you slipped. What was at stake during that game?
What was at stake?
Yeah.
The game.
And what if you would have lost? What was at stake? If you wouldn't have won?
I mean, I played exceptionally well that game. I mean, my scholarship could have been risked, but I don't know what the scouts thinking.
Is it true that your motto is let the best player and best team win?
Yeah.
So if you would have won, you would have naturally, according to your model, been the best player.
According to my model, but not according to everybody else.
That's why I asked according to you.
Okay. Yeah.
Okay, so
There's
according
a
to
lot
you,
of good players out there, and I'm one of the good players.
According to you, your career was at stake during that game. If you would have played the worst game of your life,
I mean, you got to show that you can play big during big games, unless you're nothing.
Right. So if you're losing or the game is tied, and your only choice is to clear the spotlight and make you the only prospect, and we already agreed that it was you get heated up easily.
Everyone gets heated up over.
I'm not arguing over everyone. You got heated up easily. Your career was on the line. You bumped into my client.
I slipped into your client.
You're on.
Thank you. Any redirect?
No, you're not.
Why you may step down, sir? Since you wish to call another witness. All right, the defense having rested, we turned now to closing arguments. Mr. Moore, the plaintiff's going to divide their argument?
We haven't thought about that. Probably not. I think just one plaintiff and one defendant. They probably won't go more than 5 minutes apiece.
And we'll turn first to the plaintiff to make.
And they have 5 minutes.
Yeah, to prepare? Yes. Please. Okay, we'll take the 5 minutes. I gotta get up. Plaintiff, you may make your closing comments.
If it pleases the court, counsel, and gentlemen of the jury, before I begin my initial closing statement, I'd like to take this opportunity to thank you on behalf of myself and my fellow counsels who've been extremely attentive throughout this process. I'm very appreciative of that fact, the fact that you have done so, and at this time, when we finish arguing, the case will be turned over to you so you can complete your service in this matter. Gentlemen of the jury, we have brought witnesses to the stand, and you have heard what they have had to say. Leaving the cousin of the plaintiff has told you about a previous argument between the defendant and plaintiff ending with a threat from the defendant towards the plaintiff that the score would be settled at the game. The defendant has had a history of a bad attitude and just generally being very aggressive. You've heard from the coach of the plaintiff's team, Pat Arbach, that in his expert opinion, the foul on the plaintiff was intentional and entirely malicious. He brought you the plaintiff himself, Mr. Cameron Duncan, who has told you exactly what happened from his perspective of the story and how bad he has been injured. We have a complaint of negligence on Mr. Hightower that the defendant had a duty of care to the plaintiff conducting himself in sportsmanlike conduct befitting a student athlete. He breached his duty of care to the acts committed during the game. You have a complaint of gross negligence that the defendant pushed the plaintiff with reckless disregard to his safety, and the defendant's actions were willfully, wanton, and grossly negligent. We have a complaint of battery that the defendant intentionally committed harmful or offensive contact on the plaintiff during the basketball game when the defendant pushed the plaintiff to the ground. Plaintiff's injuries were a direct result of the harmful or offensive contact committed by the defendant. Now, in basketball and most other sports, there is an assumption of risk that you can expect some fouls or injuries. For example, sprained wrist, a bloody nose, or a hurt leg. But no one who is playing basketball is expecting to, when they're getting past the ball, all of a sudden just get tackled out of nowhere and pushed into a ball rack, nearly snapping your spine and paralyzing your legs. That is way over the line of assumption of risk. Anyone who has also taken 10th grade physics knows that you don't fall forward 5 or 10 feet, you fall backwards. And as we've shown you in Exhibit D, he has suffered great trauma to his lower back and has to be careful to avoid further trauma to that area. He may suffer further injury and paralysis to his legs. He has to be careful not even to get into a fender bender, or even possibly him playing with his children and one of them accidentally jumps on his back or hits him in the wrong way, he can be paralyzed forever. Which is what this guy has to go through. Thinking of a life of he can carry his children, pick up something heavy, and he loses his legs forever. So, judge will instruct you on the law and how to follow it, and hopefully you'll find the verdict in our favor. Thank you.
Thank you very much. The defense, do you wish to make a closing statement? Continue on.
Ladies and gentlemen of the jury, I'd like to conclude this case that defendant Robin Hightower is known to be good in school, good kid in school, as we heard from the principal. He has good grades and encourages others to have good sportsmanship. If he did it intentional, then it would have affected his college scholarship. We have also heard from the artist Michael, who happens to be an expert witness, that he has seen hundreds of games and that it's not unlikely for injuries to appear. This is a basketball game. He's not a person that never played basketball before. He knows the rules, he knows how to play, it happens. Both Robin and Cameron got personal fouls. Cameron's foul was an intentional elbow to the face, while Robin's was pushed, because he slipped on a wet spot, which they never disproved. If it was intentional, then he would have been tossed out of the game, which neither of them were, ejected from the game. This comes to show that it was not intentional. Cameron didn't even know what school he went to. How are we supposed to know what he is telling you is the truth?
Even if I lie.
And even when he pushed him, he didn't fall 10 feet back. The ball rack was there. That is not the defendant's responsibility for the ball rack to be there. It's his. As we see, the defendant did not intentionally push the plaintiff, so that we cannot go under the category of battery. You cannot charge him for battery because you need all four things, as we proved that he did not have all four things. The first thing is the defendant intended to touch plaintiff's person. We disproved that he did not have intention to. The second thing is the defendant actually touched plaintiff. He had that. We all know that. The contact was harmful or offensive. And the contact directly or indirectly caused injury to plaintiff. The push didn't intentionally, it didn't give an injury, the ball rack did. But we see that he still does not have all four because he did not intend to push the plaintiff.
Anything else? No. All right, thanks. Take down your, All right, gentlemen of the jury, it's now you've heard all the evidence in the case and the arguments of the attorneys. I'm going to give you some brief instructions on the law. I'm going to ask you to retire and deliberate your verdict. Ladies and gentlemen, issues for your determination of the claim of plaintiff against the defendant are whether plaintiff was negligent by failing to conduct himself with sportsmanlike conduct during the February 9th, 2008 basketball game, and if so, whether such negligence was a legal cause of injury sustained by the plaintiff. Whether the defendant was grossly negligent because his conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of plaintiff, and if so, whether such gross negligence was a legal cause of the injury sustained by the plaintiff. If the greater weight of the evidence does not support the claim of plaintiff, then your verdict should be for defendant. If, however, the greater weight of the evidence does support the claim of the plaintiff, then you should also consider the defense raised by the defendant. And if the greater weight of the evidence does not support the defense of the defendant, and the greater weight of the evidence does support the claim for plaintiff, then your verdict should be for plaintiff against defendant. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Negligence is the failure to use reasonable care. Reasonable care is that degree of care that a reasonably careful person would use under similar circumstances. Negligence may consist of either doing something that a reasonably careful person would not do under like circumstances, or failing to do something that a reasonably careful person would do under like circumstances. Negligence is a legal cause of injury if directly and in natural and continuous sequence produces or contributes substantially to producing such damage that it reasonably can be said that, but for such negligence, the injury would not have occurred. A person is liable for negligence only if the injury to another was a reasonably foreseeable consequence of the negligence. Gross negligence meaning the conduct of the defendant was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. On the defendant's affirmative defense, the issues for your determination are whether plaintiff knew of the existence of the danger complained of, realized and appreciated the possibility of injury as a result of such danger, and having a reasonable opportunity to avoid it, voluntarily and deliberately exposed himself to the danger complained of. Plaintiff claims also that the defendant committed a battery against him on February 9, 2008. Plaintiff claims that as a result of this battery, he suffered injury and damages. Plaintiff seeks to recover compensation for the injury damages from defendant in this proceeding. A battery is an intentional infliction of harmful or offensive contact on the person of another. In order to find the defendant has committed a battery, we must find that plaintiff has shown by the greater weight of the evidence that defendant intended to touch plaintiff's person. Defendant actually touched plaintiff's person. The contact was harmful or offensive, and the contact directly or indirectly caused an injury to plaintiff. Kumar and Mr. Lisbon, are you gonna wanna have the jurors stay here and deliberate so everybody can hear what they say?
Well, that's a good point. I realize it's a little irregular, but I think that's a nice idea. We do have to get them, do we give them a copy of the complaint and the answer, Your Honor, and jury instructions?
None of the complaint and the answer, just the jury instructions. Okay, gentlemen of the jury, before you deliberate, the first thing you should do when you begin to deliberate, the first thing is to select a foreman to be the chairman of the jury and to direct your deliberation. Afterward, the foreman should make sure that each person has an opportunity to express their views of the case if they wish to. And then everybody should, ultimately, your decision as a jury must be unanimous. It must be the verdict of each and every person.
You gotta move
Declaring a unanimous verdict, you all have not reached the verdict. Who's on the jury?
This is the back row.
The back row, okay, fine.
Turn my-
However you want.